This video will introduce you to one of the most important sources of law, case opinions. In the American legal system, courts are bound to follow the holdings stated in prior opinions by higher courts in their jurisdiction, which means that those opinions are a form of law. In the next video, we will start to look at how you can use this understanding of case law to find relevant cases in the major legal databases. I will use the terms case and opinion interchangeably in this video. While the terms are not synonymous in every context, when a case is described as a law, that refers to the opinions that courts issue when resolving a case's dispute. Some legal topics are almost entirely governed by cases, but even when there is a statute about the issue, cases where the courts apply that statute to different situations are also going to affect how the law works. You will need to find cases related to your issue to fully understand and apply the law. Unfortunately, the courts do not organize their cases by topic, in the way that legislatures codify statutes after they are originally enacted. You will need to do some more research work to find the cases that are relevant to you. As mentioned in the last video, secondary sources can be a great way to locate those cases, but there are other important tools available. In the second video in this series, we discussed the distinction between mandatory and persuasive authorities. Some cases will be mandatory authorities that bind the court you are arguing before, while others will only be persuasive. In order for a case to be mandatory, it must be precedential and from the same jurisdiction. To understand whether a case will be binding, you must understand the hierarchy of courts. Remember that each state has its own court system, as well as the federal courts. Most states follow this arrangement, though a few states do without intermediate courts. Aside from disputes that begin in administrative or magistrate courts, cases start in trial courts. Because cases begin at these courts, they are often called courts of original jurisdiction. Trial courts resolve two types of issues: questions of fact and questions of law. If the parties have genuinely conflicting accounts about what occurred, the case will go to trial to determine what occurred. The parties will also have conflicting arguments about how the law applies to the facts, and the court will determine what the relevant law is and how it would settle the dispute. When the trial court makes a determination about how the law works and how it applies to the case, it will issue an opinion. While these opinions are written like opinions from higher courts, they do not create precedent. No court is ever bound to agree with the legal findings of a trial court. If the party that loses at the trial court disagrees with how that court applied the law, it can appeal the case to an intermediate appellate court. Most states have several intermediate courts, which preside over a set of trial courts, and a trial court is always below only one intermediate court. Except in rare situations, intermediate appellate courts will accept the findings of facts from the trial court and then assess whether the trial court applied the law correctly. If the appellate court believes that it is resolving a new legal question, it will designate its opinion in a case as for publication. Any published opinion by an appellate court is considered precedential, and in some court systems, certain unpublished opinions are also precedential, depending on the court rules in that jurisdiction. Trial courts are bound to follow the opinions of the appellate court that is above them, and in the federal judiciary, as well as in most state courts, they are not bound to follow the appellate courts that they are not below. A jurisdiction's high or supreme court takes the appeals in cases where there is an issue that presents a question about the law that has not yet been settled. Just as with intermediate courts, a supreme court only rules on matters of law. The opinions it issues are binding on all the courts within that jurisdiction. Assuming a Supreme Court has not later overruled itself, or the U.S. Supreme Court hasn't found that a state Supreme Court's opinion violated the U.S. Constitution, a Supreme Court opinion is going to be mandatory authority. A given opinion will likely contain multiple rule statements. Some of these rule statements will be restating pre-existing law, while others are novel holdings on the law that build on prior law. The same case can have rules on diverse topics, or closely related rules on the same topic. When an argument submitted to a court cites to a case, there must be a rule statement in that case that fairly reflects that argument. The tricky thing is that a rule is written into the larger text of the opinion, and there are no explicit signals that a given passage is a rule statement while the surrounding text is merely discussing the legal context. Sometimes the court will aim to be explicit and start a sentence with a phrase like, "We therefore hold that," but you can't rely on that. A more common way to identify a rule statement is conditional phrasing, such as an if-then construction. Keep an eye out for context that makes it clear that a given sentence in an opinion is not actually the law, such as an indicator that the court is discussing a party's argument, or the lower court's holding. This is commonly referred to as dicta. A successful legal argument will combine the rule statements from cases with rules from diverse sources of law, including other cases. While you probably won't research cases in print, it is important to understand how cases have historically been published in print, because that form of publication still structures how digital legal research functions. So, even though print publication of case law is starting to fade away, I'm going to use the present tense when discussing how cases are published, because it will still be relevant to digital research. Cases are published in series called reporters, which include every case that is issued in a given area in the order in which they are issued. This means that they are not arranged by topic, with some exceptions for specialty courts. There are two types of reporters: official reporters and regional reporters, which we discussed during the second video. If the case is from a state with an official reporter, it will appear in both the official and regional reporter, commonly referred to as parallel citations. There are two things that you should keep in mind about reporters when doing legal research: how they inform legal citations, and how regional reporters implement headnotes to help you navigate case law. This video does not set out to teach the proper method to write legal citations according to the Blue Book system, but it is important to show the connection between reporters and how cases are identified by citations. Every published case can be identified by the three core components of a citation: the abbreviated name of the reporter the case appears in, the number of the volume of that reporter it appears in, and the page number it appears on within that volume. Because most state cases will appear in multiple reporters, there is a different corresponding identifier for each reporter. The same passage will appear on different pages in each reporter, which is why there are numbers with different amounts of asterisks that appear throughout the text of a case in a commercial database. In this case, for example, a page number with one asterisk corresponds to the official reporter, while a page number with two asterisks corresponds to the regional reporter. Case law research was revolutionized in the 1880s when West Publishing began adding headnotes to the cases that were republished in the regional reporters. In tandem with reporter digests, these headnotes were used to bring together topically related rule statements across many cases to make it easier to find relevant cases. West and Lexis's editors go through a case and identify rule statements. They then reprint those rule statements at the beginning of a case. Headnotes serve several functions. They help you browse and select cases. They help you navigate an individual case, or they help you find topically related cases. When you use a legal database for legal research, you will often have lists of cases from search results. You often want a quick way to identify particularly relevant cases, and scanning a case's headnotes is one way to find them. Rather than having to scan through the text of a case to identify whether there are rule statements relevant to your research, you can first read through the headnotes to look for a relevant rule. You can first look at the topics that the rules were assigned to filter out rules that are unrelated and hone in on the topics that are related. Cases can be quite lengthy, with long discussions about issues wholly unrelated to your legal question. While some cases are neatly organized with headings, that is not always the case. You can use headnotes to jump to the discussion of law that is relevant to you. The number to the left of the rule statement is a link that will take you down to the section of the case that contains the discussion of that rule, saving you time in trying to find that discussion. The reason that headnotes revolutionized legal research is that each headnote is assigned one or more topic, which in Westlaw and the National Reporter System is called a key number. Each topic or key number relates to a narrow issue in the law, and you can find every other case in a given jurisdiction that has a headnote that was also assigned that topic. As we will explore in more depth, clicking on the topic will lead you to more related cases.